So just to get a sense of the room, how many of you are dealing with an investigation right now? Okay, so quite a few. And how many of you have, in the last year, dealt with an investigation?
Wow.
So, like I said earlier, it's a part of daily life, and certainly on the employment end, there's no shortage of things people will do at work that you would never ever imagine, but that will always require some level of a response. So, when we were preparing for this, just to go through some of the newspapers and some of the recent stories, and we've pulled some and put them up there. Obviously, this is not where you want to end up, and we'll talk about the purposes of doing an investigation. And sometimes it's unavoidable that something happens and you're reacting to it, and your actions are going to be scrutinized. And a good example right now that's in the news is OPSU. OPSU, within the last couple weeks, there's been news reports about a longtime employee who's now facing 12 counts of sexual assault, and some of these sexual assaults are alleged to have occurred at the workplace. And so it's been all over the papers, and right away, OPSU, one of the things they mentioned in their quote to the media was that they first learned of allegations of inappropriate conduct by Mr. Ford in late spring of this year. At that time, Mr. Ford was immediately removed from the workplace and suspended. His employment with OPSU has since been terminated following an internal investigation. So the next question, of course, is, well, what is in that investigation? And that's going to be something that probably will be litigated over and will really drive how the company continues to respond and likely change policies. And so you can see right away that it's so critical that you have a plan in place and that you have the right training and you've selected the right people. Sexual harassment obviously is something that's becoming more and more of a hot button issue. The Ontario government's recently passing new laws about that. We'll talk about different duties and obligations that you have as an employer to do an investigation, regardless of whether or not you think that the investigation will be substantiated. But there are a number of reasons why you're going to have to start an investigation. Certainly, as we go to the next slide, and Adam can run through some of those reasons with you.
Sure. And just to go back, I mean, hopefully everyone who's involved in an internal investigation or has been the last year, you didn't learn about it as a result of reading about it in the paper, because that is the last place that a company wants to be. But some of the typical ways that my clients learn about an issue that needs to be investigated is because someone else is investigating it. So the police show up at the company and are searching through records and with a search warrant, hopefully with the company's lawyer present. So that is also, you don't want to be in that situation, but because you know the newspaper's coming shortly thereafter, but at least you'll get a bit of a heads up before it lands a bit in the newspaper. Another way, especially if you're dealing with a competition law issue, that you could get knowledge that there could be some issue is service of a statement of claim. Usually that happens long after the criminal context is well known, but it could. There are a lot of ingenious plaintiff side counsel out there who will try and find something. So service of statement of claim, and it lands on your desk and you have no idea what happened here. It's not apparent, so you have to run an internal investigation to get to the bottom of that. And in terms of some of the issues that you might look into after it's triggered, fraud. That's a big one. If there's a product recall, you need to get to the bottom of what went wrong very quickly. As I said, if you're served with a statement of claim, there could be health and safety issues. Privacy breaches are something that we've seen explode in the last few years. And those things need to be looked into to figure out what went wrong. How did that briefcase end up, at a ball game and just left there with all kinds of personal information inside it. And it can also happen that a whistleblower comes forward and tells you what's going on. That's usually, not to say that there's ever a good time for an in-house person to learn about an issue that needs to be investigated, but usually a whistleblower will be the best because it can be contained, and you'll have a little bit more time to think about the issues before you decide what you're going to do about it. In terms of competition law issues, so cartel issues, as you saw by the police cars on the last slide, sometimes that's triggered by the Competition Bureau executing a search warrant on the premises, or in Europe sometimes and other parts of the world that's called a dawn raid. They'll show up at 6 a.m. before anyone's got there, and then they'll serve it right at first thing in the morning, and they'll give you a bit of time to let people show up, but that's how it would work. There could be, and in those circumstances, obviously, you're going to want to ascertain what's going on, at least on a preliminary level, very quickly by reading the search warrant. And there's all kinds of other issues to deal with apart from the internal investigation issue. It's also managing, the rights and obligations that the company has in the face of that search warrant. But it's also an opportunity. This is really when your internal investigation is beginning. It's beginning at the service of the search warrant, and this is going to give you some clues regarding the issues that you're going to be looking into. Internal whistleblower coming forward, so I mentioned that. Maybe it's, no one has picked up on the fact that there could be a potential breach here, but there's an internal audit, and the audit finds that there's a significant issue that needs to be looked into. From a timing perspective, those are more ideal than being hit with a search warrant from the perspective of timing of the investigation.
So once the complaint comes in, and let's be clear, it's not always as straightforward to figure out if there's a complaint that's going to trigger an investigation. You're going to have I'm sure you all have policies that have workplace harassment dealt with and workplace violence, and there will be an investigation protocol that's there, and there will be some information about how an employee is to file a complaint. So let's talk about the easy ones. The easy one is an employee comes to your human resources group, or maybe they come directly to your door as in-house counsel, and they say, I'm being harassed by my manager, or I witnessed someone punch one of my coworkers on the factory floor. Okay, we know that we're going to have to do some level of an investigation. The harder ones to recognize are where we're hearing general complaints or rumors, or we hear or we see a manager who's running through their subordinates. They can't seem to keep people, and there's been an enormous amount of turnover. Things that are not usual probably aren't usual for a reason, and that's going to be an alarm bell for you that we should probably look at this more closely and decide if we're going to actually launch a full-blown investigation. And there's really no magic words, there's no magic form to it. You don't need the employee to fill out, or you don't have to have an investigation complaint form. Certainly it's helpful, because if you have a complaint form, you're going to be able to dictate the type of information that you need that's going to be helpful when you're going to be figuring out who's going to be doing the fact-finding and whether you need to get an external investigator, and you're going to know the scope of the investigation a lot more. But if it's an oral complaint, it doesn't mean that you no longer have a duty to investigate because the person just hasn't put pen to paper. Certainly you're going to want them to do that, but once you have some level of knowledge that there's something amiss at your workplace, there's likely going to be a trigger that you need to delve a little deeper. A couple big points is that if you're seeing the same thing happen over and over again, or it's not come in on the complaint form and you don't do anything, the risk is that, as Adam said, you could be served with a statement of claim, and now you're going to be in defense mode, because you're going to have to do the investigation now. Maybe some people have moved on, so you're going to have problems with witnesses. And if you haven't acted promptly, there is certainly a risk that the employee's counsel will say that you condoned it. They'll say a reasonable person would have known that because this person was taking all this time off and they were confiding in their coworkers that their manager was abusive, you condoned it. You should have known, and that's not where you want to be for sure. Question that comes up: what about off-duty conduct? And we'll talk about the easy off-duty conduct first. So you have a workplace social, and the social is not at the workplace. Well, obviously, if you've sponsored or sanctioned it, then that's going to be something that's an extension of your workplace. And if anything happens that is against your policies, then you're going to have an obligation to investigate. But social media is a tough one because you're certainly probably not sponsoring a message board. You're not sanctioning an employee's blog, but they may or may not be doing things like posting confidential information about clients or patients. They may be complaining about their boss or harassing their coworkers. If it has an impact on your workplace that's clearly linking, if it's starting to spill into your workplace where people are feeling that they're being harassed, not at the workplace, but by comments that are made on a message board, then you're going to have an obligation to investigate. Ontario's workplace harassment laws, as you all know, are interpreted very broadly. There are always going to be limits, but because of that being enshrined by statute, there is certainly a heightened responsibility on employers to be aware of what's happening. Now, you're never going to be aware of things if people don't come forward, so there is a balance there, but if you start hearing about things, and even if the employee comes to you and says, well, so and so is posting things on their Facebook about me and they're not true and they're really bothering me, the fact that they may be done on an employee's off hours will not necessarily excuse you from having to do an investigation.
Right. And in terms of the competition law considerations, once the trigger is pulled, once you know that there's an issue to look into, the context, as I mentioned before, is the Competition Bureau's immunity and leniency programs. So what these are programs that provide significant benefits to whistleblowing companies who cooperate with the Bureau's criminal investigation. So just to give you a sense of the magnitude of benefits that you get, is the first to come forward and cooperate gets complete immunity. So that means there's no requirement to plead guilty to an offense. There's no need to pay a fine. No one goes to jail, provided everyone cooperates. So in that context, where the fines are generally in the millions, the benefit is huge. The second so it becomes a race for companies to get in the door to the Bureau and spill the beans. The second in has to plead guilty, but they get a reduced sentence recommendation, and there can also be benefits for employees. And third gets a slightly worse deal, and on it goes. So the need for speed, the need to be the first one in there or the second one in there, is very significant. So as soon as you get a whiff that there's an issue, that's how these things are uncovered. So time is very much of the essence. And in terms of time, what you want to do is gather enough facts that you can proffer in a without prejudice meeting with the Bureau the evidence that you have that an offense has been committed, and then give that to the Bureau, and then sign an immunity or leniency agreement, depending on whether you're the first, second, or third one in. Again, the context in a competition with a competition issue is speed, the need for speed. So if there's a search warrant, obviously that's served, the Bureau already knows about it. You won't get immunity, but you might be able to get the second in leniency, which will be the highest discount on fine possible. And so there'll be a need to quickly evaluate what's going on and make a decision on whether or not you participate in one of the Bureau's programs. If it's a whistleblower that comes forward with information or a compliance audit that during which you uncover the information, there is more flexibility in terms of timing, but not all that much, because you still have to think that, well, if I found this, someone else could find it. So if I want to make sure to get immunity, get the full pass, I got to get as much information as quickly as possible, and then go to the Bureau to participate in the program.
So we've spoken a bit about duty to investigate, and again, from the employment law context, there are specific statutory obligations that you're going to have to comply with if you receive notice or have an idea that there could be a complaint brewing. And definitely when we are talking about harassment, you've got, like I said, Ontario's relatively new workplace harassment laws, similarly with workplace violence. And another one that's not up there is occupational health and safety. If there's a critical injury, you'll know that you have an obligation to do an investigation, but there's also specific timelines, and you're probably going to get the knock at the door from the Ministry of Labour, which is not how you want to spend a Monday morning. I'm sure they're wonderful people, but they can be wonderful people at places that aren't our workplace. The other big one is human rights. And human rights, as you know, is an interesting beast in terms of the application process is very much geared to be as easy as possible for people to launch applications, and you'll know that you may get the odd application or complaint that you think is completely baseless, and yet it's on your desk, and what are we going to do about it? The fact that you might have an employee who's a malcontent or someone who generally likes to cry wolf, again, will not excuse you from the obligation to investigate. The case law on whether or not there's an independent duty to investigate under the Human Rights Code is a bit mixed, but I'll get to my advice. My advice is you're always going to want to take these things seriously. Now, there is a case from 2014 that the Human Rights Tribunal dealt with. And what happened, the case is Scaduto and Insurance Search Bureau. It's a 2014 decision. What happened there is an employee was dismissed, and he said he was dismissed because of his sexual orientation. There was no basis for the allegation, and in fact, the tribunal ultimately ruled that there was no discrimination. But the employee said, not only was I discriminated against because of my termination because of my sexual orientation, but I was also discriminated against because you, Insurance Search Bureau, you didn't even investigate. You did nothing. And the tribunal said that wasn't on its own going to be a breach of the code. But they made that ruling in kind of a, as adjudicators sometimes will, in a way that's not really clear. What they said was there can be no independent duty to investigate absent actual discrimination. So how do you find out that there's no actual discrimination if you don't investigate? You can roll the dice and say, yeah, we think that Mr. Scaduto is completely out of it, so he wasn't discriminated against. So I don't think that that's necessarily the ruling you want to rely on. Then the tribunal did go further. They talked about, if you're going to investigate, we need to have some fairness to employers, which is refreshing. The complaint has to be communicated by the applicant or be otherwise known to the employer in a manner sufficient to engage the obligation. And the substance of the complaint must be related to the code. And that's important as well, because a lot of the times you'll hear people will be upset because they didn't get overtime or they didn't get preferential treatment on an incentive compensation. And if they don't say that it's tied to some sort of protected ground, well, the Human Rights Code is not going to be engaged. And so the real advice comes at the end of the decision, and I think this is really how you should be operating. As the tribunal said, employers are well advised to investigate human rights complaints, as the failure to do so can cause or exacerbate the harm of discrimination in the workplace. Internal investigations provide employers with the opportunity to remedy discrimination if found, and can prevent applications being filed with the tribunal. They also limit employers' exposure to greater individual and systemic remedies. The failure to do so is at their peril. So really, I think the case, and you're going to have situations that may come up where you're going to get an application and you will not have ever thought or heard or known about any of the allegations that are met, and so the time for investigating is now done. Well, you will be able to rely on this case to say, okay, there was no actual discrimination, and that's really why we didn't investigate. But if the facts are different, and if you had an inkling, just because the Human Rights Tribunal or the Human Rights Code does not have a positive obligation written in the statute that says employers must investigate all potential or allegations of discrimination, does not mean that it's not going to be something that you need to be aware of. So again, be vigilant, but when you do have the kind of off-the-wall complaint, there will be some protection for you in the case law as it stands right now.
So we'll move on to planning the investigation. You want to talk about objectives now?
Sure. So there can be a lot of different objectives in when you're going to be planning the investigation and starting the investigation, and some of it will be dictated by timing. And certainly, as we said earlier, there will be legal obligations and you'll have a duty. So it may be that the investigation is going to be predominantly for fact finding. It's always going to be, your final report is going to be based on what you find. And so the investigation can serve as the basis to establish the good faith belief that an employee engaged in misconduct to justify termination. Just cause terminations, as you know, are very, very difficult. And so the more due diligence you've been able to demonstrate to the adjudicator or the judge, the better. You may do an investigation because the ultimate remedy may not result in termination or even discipline, but it may result in a change in policy. So that can be important when you're talking about finding out what's happening in your workplace so that you can properly institute corrective action or different remedial measures. Sometimes when you're on the front page, you want to make sure that you have an investigation that's going to be able to work its way into a media statement so that you can hopefully be able to absolve yourself from any sort of wrongdoing. If you have been on, if something leaks to the press and you're searching for facts, you're going to want to do an investigation because that may be the best way for you to show your employees and the world that, well, actually there was no issue here. We had an external investigator come in. This is what we found, and we now will be discrediting whatever the complaint was that came forward. Certainly, though, no matter what the objective of the investigation, you need to be acting quickly. Regardless of whether there are timelines that are set down by statute, as Adam mentioned too, in the Competition Bureau, or the competition sphere, it can be critical as to how quickly you're able to finish your investigation so that you can come forward with any sort of information that the Bureau might be interested in. But the faster you act, the better. And just think to yourself as well, how will things play out in a statement of defense? If there's months that have passed from a potential complaint and you haven't started an investigation until much, much later, that's going to be an issue. So the faster you can get at it, the better.
And from the competition law perspective, the objective, if there's a single objective, is to gather sufficient evidence so that you can determine if there is a potential violation of the Act here, such that you want to take advantage of the leniency or immunity programs. So again, emphasizing the need for speed. I guess a secondary issue is if you decide that you're not, that you don't think this rises to that level, you need to develop a strategy to defend the conduct if and when the issue arises that's outside of your control through criminal charges or a class action. In terms of the formal planning stage of the investigation, once you're there, once you're sitting down at your desk and planning, literally writing out a plan, you're really at the second stage of the investigation. The first stage was the triggering event, how this got to your table. And it's at that point that you really get a sense, the preliminary sense of what is going on here, what could have gone on here, and that will inform, at least initially, how you will roll out and plan the investigation. So if you're in the context of the Competition Bureau serving a search warrant, you'll want to read the search warrant to see what are the issues here that the Bureau is looking at. You'll want to go to the court file and get the information to obtain to see what the Bureau has alleged could have gone on here based on the information that they already have. That will give you a sense of how to plan the investigation. So before you put pen to paper, what you want to do is use the preliminary information to understand the issue at the highest level, kind of size the issue, draw borders around the issue, to say, okay, who's potentially involved, who's definitely not involved. Are we dealing with cartel conduct, or are we dealing with something that's less serious than cartel conduct? Because although I'm focusing my remarks today about cartel conduct, it is possible that the Competition Bureau would execute a search warrant for conduct that's not necessarily criminal in nature. So, for example, abuse of dominance type anti-competitive conduct is not criminal under the Act. It is an enforcement priority for the Bureau and could carry large administrative monetary penalties, but that type of conduct is not criminal in nature and is not as serious as cartel conduct. So you want to size the issue. You want to get a sense of how deep this type of conduct goes. What territories are involved? Is this limited to one person at one desk, or is this the entire sales team in multiple jurisdictions around the world? You want to know that the time frame that could be at play here. You'll want to know that for what you do about document retention destruction issues. And again, you'll want to make a list of who's involved. Get a preliminary witness list going. So, my advice in terms of planning is, in the competition world, we actually will draft a plan, and it will be continuously updated as the investigation rolls forward. I don't know if there's anything that formal in the kind of investigations you run, Andy, but that's something we do. It's more than a checklist. It's an actual plan.
Yeah, sometimes, as you know, when you're calling us, the house is already on fire. So the plan is to get water on the fire.
Right.
And that really goes to the next point. That's a good point that Adam raises. Is we're going to talk about who's going to be your investigator, but the other important issue is how formal does this investigation need to be? Maybe this is just a simple workplace disagreement, and you may be doing investigations without even thinking, because they're just conversations between you and another employee, figuring out what's happened and resolving it that way. Obviously, though, there are going to be those times where you're going to need to document things, and the formal investigation is going to require you to engage multiple employees or individuals. There's going to need to be meetings. And there's going to need to be a formal investigation report that's issued, because there are going to be ramifications of whatever it is that happened. The decision of who your investigator is critical, and it's critical for lots of different reasons that we'll talk about. Options are, if it's an employment or competition, whatever, maybe it's the human resources. First of all, is it internal or external? We should take a step back. Are you going to conduct this in-house, or are you going to need external advice or an external advisor? If it's internal, which department's going to be dealing with it? Is it going to be human resources? Is it going to be your in-house counsel? If you're a retailer or any sort of merchandiser, then maybe it's your security and loss prevention team. It really will depend on the nature of your business, and it's going to depend on the nature of the issue. If, though, you think that it's best to go external, well, then the next question is it going to be your external counsel or some other external counsel? Will it be not a lawyer and just someone who specializes in investigations? That's certainly another option. But those are going to be threshold issues for you to consider. And when you're considering them, we've listed a number of different factors for you to consider. Adam already mentioned at the outset, you're going to want to have an assessment or a litmus test as to how serious the issue is and how severe the allegations are. The identity of the person against whom the allegations are made. Is it the CEO? If that's the case, maybe you're going to need to go external. Whether any particular expertise is required, I certainly don't. I'm not going to be the one Adam calls to do any sort of fancy economic analysis. So that is going to be a factor that you're going to have to consider. Workplace dynamics. Sometimes investigations, as much as you want to keep them confidential, employees generally know when something's up at the workplace, and so if there's a real concern about impartiality, or if the person who's the target of the investigation is someone who has a lot of connections to everyone in the workplace, then that may be when you need to go and get an external investigator. We'll talk about whether the parties have lawyers, and that is a question we'll deal with later on. If you're doing a witness interview and the witness says, I'm not going to meet with you unless I have my lawyer present, if that happens and you try to coax the employee to say, you really don't need your lawyer, and they're adamant on it, then maybe you want to consider as to who's going to be asking the questions in that meeting. And the last couple of points, they're obvious, and I'll give you an example afterwards, but possibility of litigation or enforcement activities. So if this really plays into the very first one, the nature and the severity of the allegations. Can this issue really blow up? And if it is, then I think we want to make sure that we're really, really being stringent. Not that you otherwise wouldn't, but you're really going to dot I's and cross T's. And cost. Obviously, it's going to be cheaper if you do everything in-house. If you come to Dentons, obviously it's going to be very, very efficient. So that's going to be a good thing if you need external advice. But there is still going to need to be a cost. And a good example of what can happen when you don't make the right decision is there's a case in Alberta. It's Elgert and Home Hardware. Maybe you've heard of it because it's something that's a lot of people will reference when they talk about who the investigator should be. So what happened in this case is you had Mr. Elgert. He's working in Alberta. He's a 17-year employee, and he's a supervisor at Home Hardware's distribution center. And he ends up getting fired because he's accused of harassing a female employee. The female employee's father actually works at head office in Ontario, and so the complaint comes through, and the father or the senior guy at the distribution center, he hears about it, so he assigns and it was a supervisor at the distribution center to do the investigation. Now, on its face, that's not a bad move. It's the supervisor. He's a manager. Why wouldn't he be a good pick? Well, he was high school friends with the guy at head office, and he had never had any training in investigations. He'd never done a sexual harassment investigation. So you can see where this is going. So they bring Mr. Elgert in for the investigation, and in addition to the assigned investigator, there are a couple other managers, and the interview goes on, and one of the comments, because Mr. Elgert's trying to understand what exactly the nature of the allegations are, and they're having some trouble communicating them to them, and one of the comments that comes back from the investigators is, come on, you know what you did. Not great. So he's dismissed. And on the basis of this investigation, and the case goes to trial. It's a jury trial, which is unusual in its own, but the evidence that comes out was that the validity of the allegations was really questioned because just a few weeks before this whole issue came up, Mr. Elgert had reassigned the female employee away from working with her ex-boyfriend because things were not working out on the workplace floor. And the other problem was that there had been testimony from two employees who had heard the complainant saying that she would get even with Mr. Elgert after he had transferred her to a department away from her boyfriend. So there was no substantiation to the allegation of sexual harassment. And so what happens to the employer? So he's a 17-year guy. You don't need to be a rocket scientist to know that that's going to be expensive and a without cause termination. So he got 24 months. But it wasn't just the notice that's the problem. The problem was that there was all of these missteps in the investigation in terms of who did the investigation, how it was run. And as I go through case examples throughout this presentation, you'll see that it's expensive. And what happened was that in addition to the 24 months of salary, he received $60,000 in damages for defamation, $200,000 in aggravated damages, and $300,000 in punitive damages. Now, jury awards, we're not the United States. Thank goodness for these types of issues.
Those are huge.
Yeah, we don't have that, and so it was scaled back on appeal. But the bottom line is you got two issues here. One, you've got a real monetary issue, and two, you've got reputational harm. This case is out there, and it could have been really dealt with. There was likely nothing. That's clearly what the courts ruled, what the jury found, and there was an obligation to investigate. But it just goes to show that some of the basic questions up front, like who is going to be your investigator, that's going to be critical as to what happens.
And in the competition law, sphere, it is generally outside counsel and specifically competition law counsel who run the investigation. And there are several reasons for that. As Andy mentioned, the exposure is just so high. You'll want to, as much as possible, insulate the investigation through privilege. And also you need the subject matter expertise. You need someone who's going to be able to look at the facts once they're gathered and give advice to the company on how to proceed next. And you don't want a dabbler at that point. You want someone who you'll be able to justify to the board of directors, look, yes, we're pursuing this plea agreement with the Competition Bureau and the PPSC. It will cost the company millions and millions of dollars, but we're saving millions and millions of dollars by doing it. You'll want to know that you have the expertise to back up the advice that ultimately gets given to the company. So in terms of who's the investigator, privilege is obviously a key issue to consider. I mean, in some circumstances, I think that might come up when Andy gets the call. Privilege might not necessarily be something that is absolutely essential and that you're gonna pay for. Do you want to?
So how many of you, when you're doing investigations, is this issue the top of mind issue? And of course it is, because something's going to happen in that investigation. Maybe some facts come out and you don't want to have to disclose them. And so there are things you can do, and we'll try and go through them quickly. But if you're going to be doing it in-house, as you know, you can be providing advice to the business, but you can also be providing legal advice. And so what the court's going to be looking at is, when that report was made, what was the purpose of it? Was it just fact-finding? Were you doing it because you anticipated that there was going to be litigation? And if that's the case, you're going to be able to be covered by litigation privilege. Or did you go and get an external lawyer and they were providing this report because you asked them to do that because they needed to provide advice to you on a sensitive employee issue and whether or not you were going to dismiss something? And then maybe it falls under solicitor-client privilege. By and large, if it's a fact-finding mission and you've got your human resources people who have gone and got witness statements and interview notes, it's going to be very tough to have that cloaked by privilege. And if you go and retain an outside counsel to do the investigation, simply because they're a lawyer, it's not going to make it privilege. Just as because you are lawyers, every email you send is not covered by privilege. It's always going to go back to what is the purpose of the email that you're sending, and what's the purpose of the act that's happened. So if you are going to engage external counsel, some ways to really ensure that it's privileges: get the lawyer to retain another lawyer to do the investigation, and that lawyer. So if you were to call me and I was to engage another external counsel, then I would instruct the external counsel that I need you to go and investigate this incident and gather facts so that I can provide legal advice to my client, and then it's cloaked by solicitor-client privilege. The other way to do it is to really set out the terms of whatever is being asked of your lawyer in a retainer letter. So have the retainer letter say that the purpose is to provide legal advice, it's not fact-finding, and then to gather those facts so that you can provide the legal advice. At some point, though, if the report comes back and it's very favorable, you're going to want to get it out there. And so you're going to have to talk about waiver of privilege and how narrow that can be. So again, these are questions that should be addressed on the front end, because it is something that comes up, and we'll talk about a little later about investigation notes and things you can do to try and keep those privileged, because there are situations and there is case law, as you may have heard of the Bruce Power case that happened a while ago, and how you can get notes put on privilege. But the main point is, simply because you've got a lawyer involved is not going to make it privilege. You really are going to have to consider, okay, why are we doing this? And if you can show that report is inextricably linked to the litigation, and one of the best ways is going to be timing. If the claim has come in, then that's going to make it easier. But if you're investigating pre-litigation, one of the things you may be asking the lawyer is to assess possible litigation risk or assess possible liability. Right. That type of language will be helpful when you are fighting a motion to say, we're not going to produce this because it's privileged.
Right, and so if privilege is important, you need to think about how to protect it as much as possible. So I'll mention a series of cases regarding Kellogg, Brown and Root. It was a series of cases that went back and forth between the D.C. District Court and the D.C. Court of Appeal in the U.S. And at first, the district court said that there's no protection in an internal investigation regarding non-lawyer documents, notwithstanding they were prepared for the purpose of the internal investigation. And that had to go back and forth to the Circuit Court of Appeal, which said, no. If it's prepared for the purpose of litigation, then there is some privilege that accords to it, not solicitor-client privilege, but litigation privilege. But because it wasn't done by a litigator, that was some low-hanging fruit for the plaintiff's counsel to take a run at. So think about not necessarily who's going to win at the end of the day, but how do you insulate and try and make sure that plaintiff's counsel won't take a run at it, that it's pretty clear from the way things are organized that if they try and challenge it, they will not be successful. Another thing to keep in mind if you're dealing with European in-house counsel, their communications with the company are not subject to solicitor-client privilege. So if if head office is in Canada and you guys are making the decision on whether or not it should be in-house counsel that runs the investigation, keep that in mind. So I think that's it, and we can move on to spokesperson.
So very briefly, we had a client seminar for our labor and employment clients about 2 weeks ago, and we had one of our contacts come in and talk about communications in an HR and labor relations crisis. And really basic advice, but really important advice. And the most important thing is have a strategy and make sure you only have one person who's the company's spokesperson, because you don't want to have two people saying things that are completely different or even slightly different. You want to have a uniformity of message when you're managing in a crisis, and involve your legal counsel. This isn't a sales pitch. This is really just a managing risk issue, because you may have the CEO come to your door and say, don't worry, I'm just going to write, it's just going to be like a really quick message to the media. It's just going to, I just think we need to get some facts out there. Don't worry about it. As Karen Gordon said in our presentation, worry about it. You want to make sure that whatever that message is going out is not going to open you up to another investigation or give a fact that you haven't even disclosed to anyone, or an inadvertent waiver of privilege, any of those things. So really, really be careful with when you're going to be speaking to the media.
So in terms of setting out the plan, the first thing you'll want to do is go through, see what the policies are, the rules. If you're dealing with sexual harassment, you want to make sure that you review the company's sexual harassment policy. If you're dealing with competition law, you'll want to get advice and make sure you know what what section of the act you're dealing with and how it works. And then you want to know the facts. You're trying to gather the facts to tell you whether or not you have a problem here. You'll want to plan a witness list. And you'll want to know, okay, these are the employees who are potentially involved, who might know something. And you also want to know, what's the order that we interview these people in? In the competition law context, you might not have the luxury of time to think about it too much, but you'll want to know, do I need to speak to person number one before I speak to person number two? Because they might have something that's relevant to what person number two is going to say. You'll want to plan the investigation to be as confidential as possible. You'll want to work on the company's document retention, make sure that IT is teed up and they know what to do when the police show up. You'll want to make sure that they have their document hold protocols in place. Whose emails did the Competition Bureau seize? Whose hard drives did they seize? when they rated the company. You'll want to know all that because you'll need copies, and generally you can try and get that from the Competition Bureau. But to the degree there's backup, that's a good place to start as well. You'll want to start setting out a preliminary chronology of events, stuff that you think people are already looking at as the potential chronology. You'll want to supplement that from what you see in the documents. And in terms of temporary changes at the workplace, you have to think about, okay, this is the person who we need to talk to. He doesn't work here anymore. How do we go about getting evidence from that person? And you'll also have to think about if it's pretty clear or it becomes clear that employees or one employee engaged in potentially criminal conduct, what do you do about that? You'll call it, probably me and Andy, because on the one, there's a tension there, depending on where you are in line, to the Bureau participating in the leniency program. There might not be any kind of help that that will be accorded to the employee in the normal course of conduct of the leniency program, but the Bureau may depend on that person's evidence. So it's a delicate balance, and you'll need to think about whether there's an internal amnesty program and whether the Bureau does or does not want to see an internal amnesty program for implicated employees. So turning to documents and interviews. So in terms of reviewing the documents, so at the trigger you want to determine as much facts as possible on a preliminary basis. And when you're reviewing the documents, you want to supplement that before the interviews to the degree possible. And some cases are told in the documents. I mean, that's generally a rule of litigation. Generally, is there are some cases where you don't. I mean, you do need the people to corroborate what's in the documents, but the documents really tell the entire story.
Sorry, Adam. I think Nadia, do you have a question?
Oh, sorry. Go ahead.
No,
go ahead.
Don't worry.
Since I'm interrupted.
Sorry, I didn't see you.
So just going back to the planning phase, obviously at that point you have to make a lot of decisions about scope, right? Like time
Yes.
frame, who you're going to talk to, what documents you're going to look at. I think it's fairly obvious what the risks are if you set the scope too narrowly.
Yes.
But what are the risks associated with going too broad, and how do you protect against those?
Yeah, that is a risk, and the biggest risk in the competition context is if you try and boil the ocean, you're out of time. Like you're doing as much as you can. You're doing a very thorough job, but in the end, there's very little value you get out of that investigation because it's just way too broad. So you need to try and focus it as much as possible using the clues that you get from the triggering event. So that's the biggest one, and obviously there's other many more risks that are associated with going way too broad, which is that you make a lot of people nervous who don't necessarily have to be, and people start talking. And generally, you'll see one of the tips we give later when you're doing the interviews is, to the degree that you can limit people talking about this, that is key. And it's key not only from protection of privilege perspective, but just in terms of people knowing what evidence is theirs and knowing what other people told them. Once you have that people talking, there's cross-contamination. People don't remember, did I hear this from my colleague, or did I know this because I was there? So those are two of the most obvious things that come to my mind.
Yeah, and it's a good question, Nadia. The other important point is, and Adam kind of touched on it, is the more people that are involved, the more loose lips there are, and the more people know that something's going on. And really, from an employment end, and it's much easier because you're not going to have to be dealing with lots and lots of people and potentially a price fixing. The two critical players are going to be the complainant and the alleged wrongdoer. So let's start there. And then after you go through those interviews, because one of the questions is going to be, were there any witnesses? Is there anyone else I should talk to? And that's going to help you, because as we get to some interview questions and strategies and tips on that, you'll have a script. You're going to need one.
Yes.
But it's really important that you listen and you're not just so wedded to the script that you're missing what the interviewee is telling you. So you're not just going through the checklist. And so if you start if you start with those two people that you're going to interview, that should hopefully help you when you're considering what other witnesses we're going to need to gather up, rather than, okay, we're going to need to speak to everyone in the operations department off the top, because that's not going to be helpful.
And one more thing to answer this question, even if you start narrow, the one thing that I would, if you're running these investigations, the one thing I would say is you have to remain flexible. If new facts come up, you can't look at the plan as, I'm going to live and die by this plan. And as a matter of fact, the advice that I would give in my practice is there are many different versions of the plan. As new facts are uncovered, the plan gets changed. So it's plan 1.1, plan 2.0, plan 3.5. You have that, and you know that you changed it because you learned something either in the documents or during an interview, and oh, I have to add someone to my witness list, or I can take someone off. Usually it's add, not take someone off, but yeah, even if you start narrow, be prepared to be flexible and expand as necessary.
And, sorry, go ahead.
Sorry.
No, go ahead, absolutely.
My question is tied to document retention, and your next slide shows
Yep.
document review. Can you do some comments on personal information that may be either on the company computer that's personal in nature, because that's part of the course, or alternatively, now there's a lot more bring your own device processes in place at companies, so it's actually not the company's device, but has company information on it.
So in terms of the first question about we have information about people's personal emails, that's just going to be an instruction to your investigator that we're not interested in what people were doing necessarily on the weekend or whatever party they've gone to. We are interested in this narrow issue, and so you're going to have to trust the investigator to ensure that they are not just looking through every email. They may have to look at emails just to get a sense of what it is, but we don't have to document it, we don't have to print them out, we don't have to disclose them. To the extent that there is personal information on a on a person's own device, that becomes very tricky. Hopefully you have a policy on it, because the policy will likely have some language saying you should not be putting certain information on your own device. But if that's the case, I mean, what you'll have to do is ask. Really, you'll have to say, look, have you sent emails to any other device? And if so, we're going to need them. And then that could become very sticky. To me, that's not necessarily a privacy issue. Privacy is such a hot button issue now for in-house counsel, especially on the employment end, because people love to talk about their rights, and people love to talk about their right to privacy. Ontario does not have private sector privacy legislation. There is no enshrined right to privacy in terms of a statute that says you have no right to go through my workplace computer. There is always going to be a test of reasonableness, and the Supreme Court of Canada has said that we can't be rummaging through employees' personal filing cabinets, and so the workplace computer has become, a hybrid of a personal and workplace-owned computer. But again, that should be addressed through policy. You may not be able to completely extinguish an employee's thinking that they have a right to privacy, but you can certainly diminish it. And you can say in policy that you do not have a right, you should expect no right to privacy. We may have monitoring of your computer. We may do lots of different things. And that will really help to play into how you're going to deal with the situation that comes up with the investigation, where you have situations where, like you pointed out, documents or emails may or may not be on the workplace computer that you're going to have to get at.
So just rounding out the discussion about document review, you'll want a document collection plan and a review plan set out in the document, in your planning document. You'll want to develop and revise your interview schedule based on what you learn in the documents, and you want to keep updating, as we just mentioned, the investigation plan depending on what you're learning as the investigation unfolds.
So this kind of takes us to interviews, and we've discussed some of this, so we'll try and move through this fairly concisely. When you're going into your interviews, you want to make sure you have a goal. You're looking to establish the full story. You're looking to find out things you don't know, as we spoke with the question. There may be other witnesses that you're going to need to speak to. So you're going to those interviews with open ears. It's not a cross-examination. You're not trying to you may be trying to catch the employee in a lie, but you're not trying to do so with leading questions. You want to be impartial and certainly don't express your own opinion. So when you finally have the person in the room, and you're going to be commencing your interview, the next thing that you should be doing is give the instructions to the witness. So you're going to go over a summary of the process, briefly describe the nature of the investigation. You may need to explain to the employee that we're under a legal obligation to conduct the investigation. And the next 2 points are so important. Stress the confidential nature of the investigation, that people shouldn't be sharing information outside of the meeting. And also the prohibition against retaliation. And that's going to get into the next few slides in a moment, because that's going to be very important when someone hears that someone has launched a complaint against them. You're going to want to make sure that you caution them from doing anything to retaliate against that person. An employee will have a duty to cooperate. There will inevitably be those employees who say, I really don't want to be involved. Can you please go and talk to someone else? And unfortunately, there could be knowledge that they and only they have. And so if you're faced with that situation, just remind the employee that we need them to be cooperative. You can assure them of the confidentiality of the investigation. And then, we can only do as a company, we can only make findings on information that we have. And so it's really important that people provide us with the necessary information. And remember, you're looking for facts. You're not looking for necessarily subjective opinions. This is a fact-finding mission. The fact that, if the employee wants to express opinions about things, fine, but really, really try and gear the investigation to meeting to facts as much as possible. Always have two people in the room from the company. One person should be the primary questioner. The other person should be the primary note keeper. You want to have a witness there to ensure that this isn't going to become some sort of issue over what someone said or what someone didn't say. In a union setting as well, there's representation issues. I'm not sure how many of you are dealing with unionized environments. If you are, you'll know that you'll need to have a union steward when you're interviewing the employee. You'll want to make sure that you've looked at the collective agreement to see if there's any particular nuances about investigations in terms of timeline. So that's always things to keep top of mind.
And in the competition law context, we generally also have at least two people present. Those, again, are external competition lawyers hired by the company, some to keep notes, others to ask questions. And in the competition law context, I mean, the interview will really be structured to preserve privilege in addition to fact-finding. So you want to, again, limit the participation to lawyers. And remember that at the end of this, what you're getting from this employee is information that the company will possess, and that information will have value in terms of whether or not you can use it to participate in the immunity or leniency process. So as we'll see in one of the next slides, you'll want to make sure that everyone in the room, including the employee, is on the same page as it concerns those issues. What we're doing here and to whom the information that's collected in this investigation, to whom it belongs. So determining who gets interviewed, you want to figure out who are the witnesses, who they are. Do you want to speak to the alleged wrongdoer? And if you do, are they going to be the first, the last? Do you even have the time luxury to think about it? You'll also want to make sure that you interview document custodians, people who had in their files, in their email files, in their electronic file folders, in their physical file folders, the relevant documents and what they mean. Sometimes it'll be clear what they mean. Sometimes you'll need an explanation of what they mean, and you'll again want to maintain flexibility in the investigation. The new facts that are uncovered during an interview will speak to what happens in another interview, and you'll want to keep updating your plan accordingly. So in terms of beginning the interview, my advice is to start off in a friendly tone. You will get more flies with honey than you will with vinegar. And the key thing, one of the key things to do at the outset of the interview is, at least in my world, is to deliver what's called an upjohn warning. And this is a private Miranda warning. So everyone's seen Law and Order. You have the right to remain silent, et cetera, et cetera. You want to deliver that message, not in those terms, of course, but on behalf of the company, that they're here on a voluntary basis to cooperate with the company's investigation. There are facts that they may have that will help the company, and that there is a privilege that's covering this investigation, and that privilege belongs to the company. It does not belong to the employee, and this is critical if you're a lawyer. You'll want to stress that you are the counsel for the company, not the employee. You are not the employee's lawyer. You want to make sure that they understand that. Those things are very much the subject of a lawsuit that was started in the Court of Queen's Bench in Calgary, that flow from the Glencore a guilty plea. This is a guilty plea to an offense of bribing a public official. The plea was that the company bribed the Chadian ambassador and/or his wife, and the company, to get all this information, the company undertook an extensive internal investigation that included interviewing the ambassador and his wife. And in the statement of claim, it says that the ambassador and his wife were not informed that this interview and the investigation would be used to facilitate a guilty plea by the company. And and it's a major, large Bay Street firm that was sued that conducted this interview. And I don't know if an upjohn warning was given, but I will say that if it was given, and if the Bay Street law firm has a record of giving the upjohn warning, that will assist them to defeat this allegation. Not to say that there's any merit to this claim. I have no idea, but that would be evidence that would help the investigator as well as the company, which ultimately owns the investigation. There's also it's also important to, as we said before, to warn the employees that they shouldn't be talking about their evidence with anyone outside of that interview room. And the reasons are not only because it could amount to an inadvertent waiver of privilege, but also because the employee might get information from another employee and might get mixed up in terms of what they know and what they were told by an associate. So it's important to keep the evidence straight in the employee's mind. So in terms of first questions, as I said before, start simple. Oh, sorry. Is there a question? Yeah.
Just a quick question. What's your view on pre-recording such interviews?
For reasons of protecting privilege, my advice and my practice is never to do that. I know that there are counsel who do that, but the more something is fact, and the less it is advice and the impressions of counsel. So the closer it is to fact, the harder it is to maintain privilege, because a transcript will not in and of itself be privileged. You'll need to do a lot more to get a court to accept that it's privileged, because facts are facts. When I'm preparing my notes, they contain my impressions of witness demeanor, such that the company will be able to say, these record not only what was told, not even in a verbatim way, but in a way that also contains the counsel's impression of witness demeanor, such that this really is preparing for litigation. So,
and just in another quick note, I mean, the first point, set a friendly tone. I think it's tough to set a friendly tone saying, hey, good news, we just want to have you in here, and by the way, we're going to tape every single thing you say. Like, that's tough. We want people to be, forthcoming and feel comfortable, and people are already going to be nervous. I think if you add that element to it, that's going to make it a bit more difficult.
Yeah.
So if we go on, and Adam, maybe you can kind of talk a bit about first questions, and then we
Yeah, I
can move
mean,
in.
my practice would be, did you see the hockey game last night? Like, you really want to get the person to be find themselves comfortable such that they're going to open up, and you'll want to start out with very softball questions about what they do, what their responsibilities are, who they report to, and at that point, although this is not a cross examination, you can ask leading questions. And you'll also probably want to probe what they know about the company's policies and what else is going on at the company.
And so if we talk about best practices, we've put some basics on this slide, but if we want to get really practical, and let's talk about that you're meeting with the complainant. So what things do you want to know from the complainant? Well, you want the complainant to confirm who the alleged wrongdoer is. You don't want to go through the entire interview assuming that the alleged wrongdoer is person X when it's actually person Y. You're going to want obviously to ask for details of the misconduct, and that means time frames, dates, etc. Who are the witnesses? Who else knows things? If there was a delay, if this complainant sat on the issue for a while, you're going to want to ask the question, well, why didn't you bring this up to the supervisor immediately? What caused you to delay? And have you previously tried to bring this up to anyone? That's going to be important. You're going to want to know what the effect of the misconduct has been on the complainant, and it's not a bad question to ask. Is what are you looking to get out of this investigation? You're not trying to set expectations, but you need to have a sense as to what's going to happen if you come back and say the investigation unsubstantiated, and this individual says, "Well, I want the person fired, and I want them to have to pay back their salary." Who knows? That's going to be something that's going to be a practical point that you're going to have to consider once you're to the point of what the outcome of the investigation is. We talk about the wrongdoer or the alleged wrongdoer. You're going to need to disclose some information to that wrongdoer as a procedural fairness issue, which means that they will need to know who it is, generally speaking. They will need to know who it is that has lodged the complaint. And there are limits on the amount of confidentiality that you can have in an investigation, because in order for the alleged wrongdoer to be able to really put a defense in as to what's happened, they need to know the details. Don't engage in an argument with either of the complainant or the wrongdoer, but definitely not the wrongdoer, and stay impartial. You're not going to make the statement, "You know what you did." That's not going to enter your vocabulary. Another important question to ask the alleged wrongdoer is, do you have any idea why this person would make this type of complaint about you? And that's going to be an interesting answer. I always love when you have to, if you have videotape, one of the best things is having someone try to explain the unexplainable. If you have videotape, show it to them. And that could be the answer to the entire investigation. They may come up with the most ridiculous explanation. Document it, because that's going to be great for your lawyers to deal with when they're doing closing argument or when they're doing questions at any sort of hearing. The last point is, confirm the accuracy of your notes, and that may involve having the person who you've just interviewed look at those notes and sign them to make sure that they're correct.
That generally does not happen in the competition law context. You will, in the competition law context, and I think this probably applies in other contexts as well, you want to think about the implications to the employee. I mentioned before, is there an internal amnesty program that's going to be offered to the person who may have exposed the company to liability, because you might need them and need their cooperation to participate in the Bureau's leniency program or immunity program. And the company needs that person to because they're the person who has a lot of the information that the Bureau would ultimately rely on. So there's value in keeping them around. They may have to be demoted. I mean, these are all things that have to be thought about. If the person during the interview makes an admission and they knew that they did something wrong, and it's pretty clear that they've implicated themselves through what they're saying, you have to think about, do they need their own lawyer? And sometimes the company will want to tell them, look, you should get your own lawyer, and we should pick up this conversation once you've had a chance to speak to your lawyer, because you want to avoid the chatting ambassador situation, where they think that you could be their lawyer, or they could be saying things that the company will maintain At that point, there is the alignment of interests splits a bit. So you'll want to make sure that they have a lawyer who's advising them, hopefully someone who knows about competition law, and will be able to say there is value to keep cooperating with the internal investigation because there are significant benefits that you as the employee can get out of A, the immunity and leniency program that the Competition Bureau offers, and B, any kind of internal amnesty program that's being offered to allow the company to participate in those programs.
Now, really briefly, on the employment end, if you're not dealing with the Chadian ambassador and you're more so just dealing with someone who's alleged to have punched someone on the factory floor, and that person says, hey, I'm not going to talk to you until I get a lawyer, you're going to do your best to talk them down from that because there's really no reason for them to get a lawyer. If they're insistent on that, you can tell them, well, if you bring a lawyer, they may become a witness if there's ever any sort of litigation. And the other point to raise with them is, we really are trying to be as cooperative and give you an opportunity to address everything now. But if they're insistent on it, we want this investigation to move forward, and it may be that you'll just say, fine, if that's how they want to spend their money, go for it. But as I said at the outset of the presentation, it may change who's going to be asking the questions.
So regarding notes, this slide was actually addressed by the last question, but you'll want to structure your notes in such a way as to protect privilege as much as possible. So you'll want to write on it prepared by counsel in anticipation of litigation and to provide legal advice. You'll want to record things like the demeanor of the witness, facial expressions, how you think they would perform in court, as opposed to just a verbatim transcript, because facts aren't privileged.
Now, I think all of that information is good to have, but I wouldn't, in the employment context, encourage you to put that on your witness notes. You may prepare a separate document, especially if you're going to try and keep this privilege, because really we want to keep it to facts. And a verbatim transcript is not the end of the world in a employment end, because we want the witness ideally to sign off that this is what they said. Because when you write the termination letter, you'll say, if you maybe write the termination letter, you will say, during our meeting you admitted to X, Y, and Z. This conduct is unacceptable, period. And then, best of luck in your future endeavors.
So in terms of next steps, Andy, you want to talk about the report?
Mm-hmm. So all good things must come to an end, including your investigation. You're going to want to make sure after you've met with everyone, is there any follow-up needed? This goes to Nadia's question. Has anything been raised that you weren't anticipating that's going to require other witnesses to be interviewed? Make sure everything's consistent with the information, and make sure that you've got both sides of the story. There's a case we'll talk about briefly about why that's so important. There's no tried and tested true way of how the report should be structured, although there are some basics. Set out the objective summary of the allegations and the evidence. Part 2 will be the conclusions of fact. And then the last part is recommended course of action. And that might not be just the investigator who decides that. That could likely be a group decision involving the highest decision makers in your company. Because on the employment end, you could be looking at termination, you could be looking at demotions or withholding incentive pay, counseling, all sorts of things. And so that likely won't be left just to the investigator. Once you have determined the outcome, you will need to tell the complainant and certainly the alleged wrongdoer what happened. So when you're going to be communicating things to the complainant, you're really going to be looking to say that the complaint was either substantiated or unsubstantiated. They don't need to necessarily know what happens in terms of next steps, in terms of corrective action. And if anyone asks you at that point, well, can I get a copy of the investigation report? There's nothing that requires you outside of litigation to provide that report to anyone. And that should be also noted to the people who you're giving the report who actually do have a reason to see it in terms of the people who conducted the investigation, the decision makers. They shouldn't be just leaving it out. They should be very, very cautious with it because we certainly don't want to have any sort of unintended leak of that information. Major important point, though, is when you're meeting with the complainant, if we go to the next slide, the alleged wrongdoer, confidentiality remains important, and there's no a retaliation. You can go over whatever your policy says about reprisal, because in order to ensure that you have a good investigation protocol going forward, you want to make sure that people don't have the idea that if I make a complaint, then I'm going to get in deep trouble from the company some other way, or I know that they don't respect confidentiality. So that's going to be really, really important. If the outcome, though, is to terminate or dismiss an employee, then what you're going to be doing is, like I said, setting out the facts in the termination letter, making sure you're not overstating things, and making just really being certain that whatever you write is not going to be contradicted from the report. Other main points, and this is now we're starting to get into litigation, is keep everything. Just because the investigation is done doesn't mean that you don't have an obligation to retain your documents, and in fact, there could become discovery issues down the road. Mark everything as confidential, and certainly do not circulate the documents widely. By following those last 2 points, you may be able to assert some level of privilege over the documents as well. In a case involving Bruce Power, and the investigation was done internally, but it was constantly stamped, confidential in anticipation of the litigation, do not circulate, and those types of precautions helped the company maintain privilege over the report.
And in terms of next steps, once you've come to the conclusion, in the competition law context, you'll want to use the work that you put into the investigation to determine, A, does the conduct that's been identified amount to a potential contravention of the Competition Act, and if so, whether or not you engage in the immunity or leniency programs. And if immunity or leniency are sought, what you do is you use the work that went into the investigation to prepare what's called a proffer of evidence to the Competition Bureau. And you have, once you call the Bureau and place a marker, you tell them you're interested in participating in the program, you have 30 days to perfect that marker by proffering evidence. And a proffer is counsel for the company meeting with the Bureau and orally delivering what the evidence will show and what's in the documents, not giving over any documents in a theoretical without prejudice setting, and you're using all the facts you uncovered in the investigation to deliver that and to ask the Bureau the question, do you have an issue here? Do you? Because if you do, we want immunity or leniency, so the work will be for that purpose. We also have a list. I don't know if we have time. There may be questions, so there are a list of common mistakes that may or may not speak for themselves, but we did want to give a chance for people to ask questions to the degree that there are any at this point, because I think we have a couple of minutes. We answered everything.
Well, we can go through some of the common mistakes, and maybe that'll trigger something and give you some examples from case law as well. One of the biggest ones is failing to provide procedural fairness, and that's critical to the alleged offender. So the alleged offender needs to know what exactly the company's relying on, what are the allegations, so that they can properly amount to defense. And there's a case involving the Lennox and Addington County, and what happened in that case was that the person who was in charge of the county's social housing program was sponsoring a convicted felon or convicted pedophile who'd been released from jail, and as part of that process, he'd been living with the manager of the housing agency and his wife, and now it was time for that person to get his own accommodation. And so there was an opportunity that came up within the social housing that there was a space available, and so the only thing that this employee did was he alerted the individual who was staying at his house to get in touch with the person who was running that particular home, helped a little bit in terms of questions and answers as to how the application process, but that was it. The parole officer for the individual notified the housing agency or the county that she thought that the employee was exercising undue influence and was actually using his position to get preferential treatment. There was no substance to the allegation, and fatally, the county never explored it. And so they just went ahead and fired the employee. They never gave him an opportunity. They did not interview with him. So he had no idea what the allegations were against him. And that was a critical mistake, and it amounted to mistakes can be expensive. This one cost $300,000. And so, again, really ensure that you're providing as much information as you can to the alleged offender because they need to be able to respond. Promising complete confidentiality, you cannot do it. It goes to the slide we just talked about. The alleged offender is going to need to know who the complainant is. They're going to need to know certain underlying facts. If you don't provide that, if you provide a complete assurance, you're not being truthful or accurate to the complainant. Failing to reach a conclusion. If you've gone through the entire investigation, you need to come to a solution. And the solution, an answer. And the answer may be that the complainant's complaints were substantiated or not substantiated. And it's perfectly fine if you may come to a conclusion that says what this person did was not sexual harassment, fine, but it was still inappropriate. And that's a conclusion. So again, that's something that you need to have top of mind. The last kind of common mistake is failing to properly coordinate with other workplace stakeholders. You may need to involve the police at points. There are going to be media issues. Certainly if you're dealing with the competition issue, as Adam's gone through, there's a number of different agencies to be aware of. And you know, maybe there's been such a serious fraud issue, you're going to need to look at your insurance policies to make sure that you have some coverage. So as a wrap-up, we've listed some core principles. We want to thank you for your attendance and deciding that you were going to spend about an hour and a half with us. That's such a long time, but time well spent, I think. So thank you so much. If you have any questions, we're going to be sticking around.
Thank you. Okay. So are you going to the next one? Yeah, I